हाय एवरीवन, वेलकम टू द चैनल। लीगल स्टडीज़ के हम CUET के कंटेक्स्ट में लीगल स्टडीज़ को प्रिपेयर कर रहे हैं यहाँ पे। और CUET में जो लीगल स्टडीज़ आता है वो क्लास 12th तक का आता है, ये हम सभी को पता है, राइट। लेकिन जब आप लेक्चर 1 आपने देखा होगा जिसमें हम क्लास 12th के जुडिशरी चैप्टर को डिस्कस कर रहे थे, है ना। तो जुडिशरी चैप्टर को जब आपने एक बार देख लिया है तो अब उससे रिलेटेड हम यहाँ पे 15 क्वेश्चंस जो हैं सॉल्व करेंगे। जुडिशरी चैप्टर अभी कंटिन्यू चल रहा है, इसका अभी सिर्फ फर्स्ट पार्ट हुआ है जिस पे हमने बेसिक्स के बारे में बात किया है। नेक्स्ट वीडियो में हम एडवर्सेरियल और इंक्विजिटोरियल दो तरह के सिस्टम्स के बीच में डिफरेंस देखने वाले हैं। तो इसकी जो हमारी क्लासेस हैं वो चैनल पे लेक्सप्रेप चैनल पे फ्री ऑफ कॉस्ट अभी चल रही हैं, तो आप देख सकते हैं। See, whatever it is that we are doing is from the books. So definitely, these videos, these lecture videos are going to keep you on track. So first you need to watch the concept lectures, then you will come down and watch these practice lectures. So दोनों को जब आप साथ में करेंगे तो आपकी contextual understanding plus आपका MCQ ability जो है वो improve होने वाली है। And in the next slide, so don't judge me for this, but I just thought that this was a very trending meme. So you have to just focus on legal studies without any mentor support. Nah, 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 that is not going to help you. What you can rather do is practice directly in our live classes. Study in our classes, live classes, which are free of cost for CUET kids as of now, where I'll be teaching you complete legal studies before your CUET paper. And trust me, this is going to be a very holistic study. Nothing can be asked in legal studies beyond this. आप इसी सब्जेक्ट को दूसरे इंस्टीट्यूशंस में पढ़ने जाएंगे, they'll charge you a hefty amount for CUET. In this particular video, you are going to get the entire legal studies for free of cost. And the best part about Lex Prep legal studies is that when I teach the subject, students also have taken legal studies as an optional in their class 12 boards will also get benefited because we also deep dive into answer writing, how to create answers out of certain questions. That is where we are going to focus. So Lex Prep legal studies is going to be there throughout, and that is why this meme. So don't judge me for this. I thought it is appropriate. Let's move ahead to the first question. This is the first question from this. On which among the following days Supreme Court of India was established? Which among the following days Supreme Court of India was established? Now please, this is where our class had started. So go to the description, find the link of the lecture, okay? Find the link of the lecture, वॉच दैट लेक्चर कम्प्लीटली। उस पूरे लेक्चर को आप 40 मिनट्स का है, 40 मिनट्स के यूजली हमारे सारे लेक्चर्स होते हैं। 40 मिनट्स के इस पूरे लेक्चर को देखने के बाद तुरंत आप इस वीडियो पे आइए और अपने अपने आंसर्स चूज़ करिए। सो यू शुड चूज़ योर आंसर। आई होप बाय नाउ ABCD में से आपने कोई एक आंसर चूज़ कर लिया होगा। एंड द करेक्ट आंसर इज 28 जनवरी 1950। सो दिस इज़ व्हेन द सुप्रीम कोर्ट ऑफ इंडिया वॉज established. Right, 26 January 1950 is the enactment date of our constitution. And in this enactment of our constitution, Supreme Court से related provisions जो थे, they came into force. But Supreme Court was constituted officially on 28 January 1950. If they say that where is the seat of the Supreme Court, where is the seat of the Supreme Court, what you will say, the seat of the Supreme Court is in Delhi, which means where the Supreme Court sits. Are there any other benches of Supreme Court? Do we have any benches of Supreme Court in India? There are no benches of Supreme Court. In our video lecture 1, we had also discussed the 227th Law Commission report. Some Law Commission report had already stated that we need to create 4 constitutional benches of the Supreme Court, which was subsequently denied. Okay, so we do not have any as such benches of Supreme Court. Yes, we do have benches of High Court, right? So the seat of Supreme Court is Delhi, constituted on 28th January 1950, and that is what we need to remember. मोस्ट ऑब्वियस क्वेश्चंस, मोस्ट प्रोबेबल क्वेश्चन आने के चांसेस हमेशा इस क्वेश्चन के रहते हैं, और इट इज सच अ बेसिक इंफॉर्मेशन दैट पीपल मिस, सो रिमेंबर दिस। मूविंग टू द नेक्स्ट क्वेश्चन, द PIL is a part of which among the following? Now this is not given in your book. This is exactly not given in your chapter 1. This is not exactly given in your chapter 1. PIL का पहली बात तो आप फुल फॉर्म बताइए. The PIL is stands for Public Interest Litigation. Public Interest Litigation. So in lecture two of our judiciary, in our lecture two of our judiciary unit, we are going to deep dive into public interest litigation. But you have to use your common sense to pick out your answer for this. So I hope you would have marked already. You would have taken a wild guess. Great. Now let us see if you were correct or not. This is the second question for the day. Now, writ jurisdiction. So, writ jurisdiction and public interest litigation are different. Writ jurisdiction is the original jurisdiction, and writ jurisdiction is basically for protection of fundamental rights. Protection of fundamental rights of citizens. Okay. Writ jurisdiction is largely for the protection of fundamental rights of citizens. That is what we need to remember. So D can't be the answer. Now we have judicial review, judicial activism, and judicial overreach. Now we need to fundamentally understand the difference between judicial review, judicial activism, and judicial overreach. So judicial overreach is a negative term, so we'll eliminate this. Overreach means that judiciary is interfering in every aspect of governance, and that is when we say that judiciary is overreaching its limits or its jurisdiction. So the Supreme Court of India and the High Courts, respectively, do not enter into the governance sphere. At times, they refuse to, you can say, take strict actions against the government because it is the court, constitutional court, which understands the limitation of its powers. They are absolutely sovereign and they can direct the government also to take necessary action only if government is not able to convince the court that the actions that government is taking right now are legitimate. When do we see judiciary interfering in governance matters or execution matters? You might have seen the cases of bail, okay, where bail matters have appeared before the High Court or the Supreme Court. And for example, recently the NewsClick founder Shrestha Purkhayastha was arrested and he applied for bail, and this was subsequently denied by the court because it stated that okay, let the institution or investigating authority complete its task of investigation. So that is where the Supreme Court usually refuses to interfere in the governance matter, even if the offender has a right to bail. So at times when judiciary ignores this aspect, they ignores the limitation imposed on its power by separation of powers, and goes on to direct the government or the legislature as to how the law should be made or implemented. That thing is called as judicial overreach. So it's a negative connotation ascribed to the functioning of the court, and that is why we will eliminate A. Now when it comes to B and C, all right, when it comes to B and C, so we need to understand the fundamental difference between judicial review and judicial activism. One thing about judicial review you should know that it is not mentioned in constitution. First things first, judicial review is not mentioned in constitution. Okay, sir. If it is not mentioned in constitution, then still why are we? Uh, uh, I mean, why judicial review is very much important? Because it's an invention. You can say it's an invention of Indian judiciary. I exactly cannot say that this is an invention of Indian judiciary because this is adopted from America, where America says that the courts are really independent. Now, judicial review is one such power that gives Supreme Court the power to review the laws made by the legislature per se. That includes state legislative assemblies, that also includes Lok Sabha and Rajya Sabha. So, judicial review is usually invoked against lawmaking bodies. Are you getting the point? जुडिशल रिव्यू में कोर्ट अपने आदेशों को रिव्यू नहीं करती है. दैट्स अ डिफरेंट पावर, वी कॉल इट रिव्यू जुरिस्डिक्शन ऑफ द कोर्ट. बट व्हेन इट कम्स टू जुडिशियल रिव्यू, कोर्ट जो है, पार्लियामेंट ने या स्टेट ने कोई कानून बनाया है, वो कानून कॉन्स्टिट्यूशनल है, वेदर दैट लॉ मेड इज एज पर और विद इन द लिमिट्स ऑफ द कॉन्स्टिट्यूशन or not, that is what the court does. because Supreme Court is the final interpreter and the arbiter of the Constitution. So whatever law is made, whether it is within the limits of the Constitution or not, that is what the Supreme Court or the High Court decides using the judicial review power. They have assumed that power of deciding upon the constitutionality. It is not given in the Constitution that the Supreme Court will interfere. There are numerous articles where judiciary or the Supreme Court has been given some powers in Constitution of India. Combined reading of all those powers gives us the sense that Supreme Court will interfere if the law is in violation of the Constitution, or you can say uh, anything which is against the principles of the Constitution. But there is one article that I would like to tell you. If you are reading about judicial review, there is one article that does not directly mention judicial review, but Article 13 is one article where it is written that no lawmaking body can make a law which is in contravention to Part 3 of the Constitution. So if law-making body cannot make any law which is against Part 3 is what, which chapter? A chapter that provides you fundamental rights. Okay, there are different fundamental rights from Article 14 till Article 32. So if there is an article that says that the lawmaking body cannot make any law which is in contravention to the Part 3 of Indian Constitution, which organ of Indian government is going to keep a check if the law made is as per Part 3 or against Part 3? It is the Supreme Court or the High Court. Okay, so that is where we see that Article 13 empowers the Supreme Court of India to exercise judicial review, but it does not explicitly mention judicial review to be present. Now, these questions can be put forth before you by any interview board. Like in Symbiosis, we have written ability test and we have interviews. So when it comes to these aspects, these are the questions that they have asked, and this is where they differentiate. बच्चे को नोएडा भेजना है कि बच्चे को पुणे? Are you getting me? So please understand the fundamental about judicial review. Now, public interest litigation is what? So public interest litigation, I would say, is a very unique innovation of Indian Supreme Court. By this, the Supreme Court has empowered a citizen, a public spirited citizen, to represent his or her case before the Supreme Court directly or the High Court directly. But that citizen has to convince the court that there is public interest involved. You cannot come to the High Court and the Supreme Court for your petty matters. For instance, there is a vacant land beside your house, and that land is being encroached by, let's say, some balu mafia. The balu mafia is putting his sand there, and because of which the right to enjoy the road is obstructed. Public inconvenience is being caused. Now, for this petty matter, you will not go to Supreme Court or High Court and say that, sir, public interest litigation, sadak block kar rahe hai. Please understand this. So the Supreme Court or the High Court will say that why don't you approach local police station to cause necessary obstruction in his activity? Why don't you go to a local district court to seek a remedy? Why are you coming to the High Court or the Supreme Court directly, isn't it? But let us say that there is a vacant plot beside your house, and the entire colony is dumping their waste in it. There is a nationwide program of Swachh Bharat Mission. There is a nationwide program of Swachh Bharat Mission that is being enforced by central government, and municipal corporations and municipal commissioners are the nodal authority that has to check for the implementation of Swachh Bharat Mission at district level. And you are also putting evidences before the Supreme Court or the High Court that there are numerous lands across your city, there are numerous empty plots across your city where people have started to use them as dumping grounds. Secondly, if you are able to establish before the High Court or the Supreme Court that it is because of the state failure or the failure on part of the Nagar Nigam that they are not collecting door to door waste, people are bound to find an alternative to dump their waste, isn't it? And because of that dumping, the public health of that region is getting affected because there is there is increase in the instances of waterborne diseases, or you can say vector-borne diseases, that are caused by house flies, mosquitoes, and everything. So as soon as public health of that region comes into picture because of the state inability, or you can say inactions, then definitely you can approach the High Court or the Supreme Court as a public spirited citizen. It is not necessary that you are personally aggrieved by the problem. It is not like that. But you can approach these courts where the executive or legislature is not taking necessary steps. The Supreme Court or the High Court will take necessary actions. But your public interest litigation should be motivated by public interest and not by self interest. That's the kind of activism that Supreme Court or the High Court has stated, and that is why it is a part of judicial activism. Now, it was not a simple thing to understand, and your books are not competent enough to help you this. This is where the explanation of Lex Prep, this is where I come into picture, and I provide you that explanation, because we have to go beyond the mile also to understand the concepts. And the concepts that you study in these classes will stick along with you for the rest of your life. And trust me, dear, if you get a good professor in your national law university, that's a plus plus. If you get a good law professor in your esteemed universities that you're preparing for, it's a plus plus. But I have seen the deficit. We don't have good faculties to teach you these rudimentary concepts at this standard. So I hope it is clear. Judicial review, judicial review, judicial overreach, judicial activism, and what is writ jurisdiction. Moving to the next question. So if you got question number 2 correctly, do mention in the comment box that your question number 2 was correct. Okay. And if you really liked the explanation, also do not forget to mention that as well. Now coming to question number 3. So if you're already here and you have found this channel by surprise, I would like you to subscribe this channel. And if you have anyone known who is preparing or gearing up to make a career in law, please tell them about Lex Prep and ask them to be a part of Lex Prep. Now, the third question is, who appoints district judges? Now, this question is not also there. This is not there in your legal studies book. This is also not there in your chapter 1. But you have to apply your common sense and elimination method here. You simply have to apply elimination method here to reach to the right answer. District judges work under, so please, I hope you would have already chosen. Who appoints की बात कर रहा है? District judges. Okay. Now it is the state government. Always remember, it is the state government, and you will find most of the times it is the governor. The oath and everything is provided by the governor. शपथ जो होती है वो गवर्नर देता है. तो स्टेट गवर्नमेंट अपॉइंट करती है. सुप्रीम कोर्ट और यूनियन गवर्नमेंट तो एलिमिनेट हो जाएगी. हाई कोर्ट ऑफ अ स्टेट और स्टेट गवर्नमेंट में हाई कोर्ट एग्जामिन करा सकती है, एग्जामिनेशन करा सकती है. हाई कोर्ट एग्जामिनेशन कंडक्ट करा सकती है, लेकिन वो एग्जामिनेशन डिस्ट्रिक्ट जज का नहीं होता है, वो लोअर जुडिशरी का होता है. एग्जामिनेशन डिस्ट्रिक्ट जज का नहीं होता है, वो लोअर जुडिशरी का होता है. डिस्ट्रिक्ट जज जो होता है वो सीनियर मोस्ट होता है, वो सीनियर मोस्ट जज होता है किसी भी ज़िले का. अब सीनियर मोस्ट जज की जो अपॉइंटमेंट होता है, याद रखिएगा, सिलेक्शन नहीं होता, अपॉइंटमेंट होता है. तो ये जो लोअर जुडिशरी में एग्ज़ाम दे के जो लोग सेलेक्ट होते हैं, जब ये 10-15 साल जज बने रहते हैं, तो ये जिला में सीनियर होने लगते हैं, तो इनको स्टेट गवर्नमेंट जिला जज की तरह नियुक्ति दे देती है, नियुक्त कर लेती है. So this is one aspect that you should remember, and it is a previous year question also, which has appeared in your different OLET papers, not in CUET per se, but has appeared in different papers. Coming to the next question, fourth. Which is the highest ranked law officer in the country? Now law office सबसे highest पूरे country में सबसे ऊपर कौन है? तो आप ये Ministry of Law and Justice मत बोलिएगा, because it's not an office, it's a ministry. Now I'm asking you about the office. Again, this is beyond your book. This is beyond your book, and this is general knowledge. Okay, and the answer, I hope you would have chosen already your answer. The answer is Attorney General of India. Attorney General of India is at the union level. He is the highest law officer. You would also know that he has a right to audience in Lok Sabha. He can be a part of Lok Sabha, he can answer in Lok Sabha, he can assist Lok Sabha in legal matters, but he does not have the right to vote. Also, Attorney General of India can be a part of any court wherever stakes of union government is involved. Advocate General, and also remember that Attorney General is a constitutional position. It's a constitutional position. Below Attorney General, the judge, the second highest officer is Solicitor General. The Solicitor General of India assists, or you can say, is an alternative, or is a substitute of Attorney General of India. Wherever Attorney General of India is not able to make presence and is busy somewhere, it would be the Solicitor General of India representing the interest of the Union of India. Now, Solicitor General and Attorney General both have equivalent powers, but let us say if Supreme Court has to direct anything towards the central government, and let us say that Supreme Court of India or the High Court of any state wants answer from the union government, they will necessarily give sufficient directions to the first law officer, that is Attorney General of India, and it is up to the discretion of Attorney General of India that he may allow Solicitor General of India also to make such certain representations or to write a reply. Now that's okay, but you need to remember that Attorney General is constitutional position, Solicitor General is not a constitutional position. Okay, Advocate General of India is the incorrect connotation. It is not Advocate General of India. Advocate General is a post, but he is a post associated with state. So as many states are there, as many state governments are there, so would be the Advocate Generals. So there are 28 states, then there would be 28 Advocate Generals. He is the highest law officer of a state, and Advocate General of India is also constitutional position, is also a constitutional post. So I hope you are clear with the fourth question. Moving to the next question, fifth question we do have. Now in this question, tell me what is the name of the judge who is the head of a criminal court in a district? It's a very simple question. Okay. Metropolitan magistrate, session judge, district judge, all of the above. What is the name of the judge who is the head of a criminal court in a district? As you know, the highest criminal court in a district is called as a sessions court, which we have discussed in our class, that इसको कहते हैं सत्र न्यायालय. क्या कहते हैं? सत्र न्यायालय. तो आंसर इसका क्या हो जाएगा? सेशंस जज. ऑल्सो यू विल फाइंड दैट इन आर एक्सप्लेनेशंस हमने देखा था, हायरार्की ऑफ जजेस को डिस्कस किया था. तो हायरार्की जब बात कर रहे थे हम हायरार्की की, तो हायरार्की हमें दो जगह पे देखनी रहती है, एक क्रिमिनल में देखनी रहती है और दूसरी हमें सिविल में देखनी रहती है. ठीक है, तो सिविल में हमने क्या देखा था? जूनियर जज, जूनियर सिविल जज. ठीक है, जूनियर सिविल जज. देन हमने देखा था प्रिंसिपल जूनियर सिविल जज. ठीक है, प्रिंसिपल जूनियर सिविल जज. देन हमने देखा था सीनियर जज एंड देन वी हैव डिस्ट्रिक्ट जज, डीजे. डीजे कैन बी असिस्टेड बाय मल्टीपल एडिशनल एडीजेस. व्हेन इट कम्स टू क्रिमिनल कोर्ट हमने देखा था जुडिशियल मजिस्ट्रेट फर्स्ट क्लास, जुडिशियल मजिस्ट्रेट सेकंड क्लास, सॉरी जुडिशियल मजिस्ट्रेट सेकंड क्लास सबसे नीचे, फिर जुडिशियल मजिस्ट्रेट फर्स्ट क्लास, फिर चीफ जुडिशियल मजिस्ट्रेट सीजेएम और फिर सेशन जज. और सेशन जज और डिस्ट्रिक्ट जज एक ही आदमी होते हैं, सेशन जज एंड डिस्ट्रिक्ट जज. तो याद रखिएगा, वन हु इज सेशन जज विल ऑल्सो बी द डिस्ट्रिक्ट जज. When he is presiding over a civil matter, he will be called as a district judge. When he will be presiding over a criminal matter in the district, he will be called as a session judge. I hope the concepts are already clear and revised. Let's move to the next question. Question number 6. Which among the following is not the first high courts in India? And again, a very simple, a very direct question. Very simple and a very direct question. It is asking Calcutta, Bombay, Madras and Delhi. So I think you would have already marked it is Delhi. Instead of Delhi, if I write Allahabad High Court, then you know that all the four courts, that is Calcutta High Court, Bombay High Court, Madras High Court, were first high courts. And these high courts existed pre-independence, which means these are the high courts which are established by the British India. British India. Like you know, for the first time, which act established the court in India? The Supreme Court at Calcutta. Now I'm asking you extra question. Supreme Court at Calcutta. Supreme Court at Calcutta was established by Regulating Act that came down as early as 1773. Now remember this, Supreme Court at Calcutta, Regulating Act 1773. Lord Impey was the first judge or something like that. That is one distant MCQ that can be asked, but it is not part of your legal studies. that can be there in your general test of CUET or general legal information. Okay, so that can be there in your GK, but it is not associated with your legal studies. Question number 7. Which among the following courts have been replaced by the Supreme Court of India? Again, a very direct question. It's a direct question directly from the book. If you had watched the chapter 1 ka lecture 1 that I have already uploaded, please go and check CLAT 365 playlist in my channel. Go and check CLAT 365 playlist. You will find legal studies का पूरा एक playlist, पूरा एक lecture बना हुआ है, lecture 1 lecture 2 करके. Just watch that, and the answer is both A and B. So Supreme Court of India had replaced the Federal Court as well as the Privy Council. Okay, go to the next question. So answer was C. 8th. Next question is 8th. Which among the how many judges were there in the starting in the Supreme Court of India? When it was established on 28th January 1950, they're asking कितने judges थे maximum? You know, maximum, that is called as the quorum. That is called as the quorum of the Supreme Court. The quorum of the Supreme Court today stands 33 judges plus 1 Chief Justice of India, which is equal to 34 judges. When it was created, I think you had already marked B, 8 judges were there. So idea was 7 judges plus 1 Chief Justice of India. Right, moving to the next question. Question number 9. How many number of judges are required to constitute a constitution bench? Again, a very direct question and an easy one. So how many number of judges are required to constitute a constitution bench? Now you know that the maximum number of judges that we have seen in a particular matter is 13 judges, and this was Keshav Nanda Bharti. This was Keshav Nanda Bharti case that came in 1973. Okay, the Keshav Nanda Bharti case that came in 1973. Maximum number of judges that we can make to sit is 15 judges, but it is asking how many number of judges are required to constitute a constitution bench. तो कितने minimum number of judges चाहिए, and that is 5. 2 और 3 जजेस के लिए आपने अगर लेक्चर देखा है मेरा, तो उसमें आपने बताया है आपको कि उसको कहते हैं डिवीजन बेंच. जैसे ही 5 जजेस बैठ जाते हैं उसको कहते हैं हम कॉन्स्टिट्यूशन बेंच. तो कॉन्स्टिट्यूशन बेंच में 5, 7, 9, 11, 13 या 15 इतने जजेस हो सकते हैं. जब भी इतने जजेस बैठे हैं तो कॉन्स्टिट्यूशन बेंच कहेंगे. अब 5, 7, 9, 11, 13, 15 ये कौन से जज, कितने जज बैठेंगे, ये चीफ जस्टिस ऑफ इंडिया का काम होता है. That is the job of the Chief Justice of India to decide whether any matter requires 7 judges, 9 judges, or for that matter. Right. So that is the complexity, how these judges are decided and all. You will get to know all of this when you will study constitution in your law school. We'll try to save the detail as we do not have that much time as of now. Now coming to the question number 10. I could have explained you that aspect, but I do explain all of this in my live classes. So definitely that is the kind of edge you get if you join my live program. How many of the following, which among the following governments, okay, it is asking which among the following governments decide the pecuniary limits of the subordinate courts. Now what do you mean by pecuniary? I asked you, I had already told you, whenever you read the word pecuniary, replace this pecuniary word with monetary, that is money limits. So it is the monetary limit of a subordinate court, and that is decided by parliament, state government, chief judicial magistrate, or all of the above. What do you think? Who decides the pecuniary limits of the subordinate courts? The pecuniary limits of the subordinate courts, which means the lower courts which are lower than the district judiciary, are decided by the state government. That is what you need to remember. Please remember this. And this again question was a very simple one, a very direct one. We have already discussed this in our class. Moving to the next part, coming to the question number 11. The subordinate courts within a district, including the district judge, is under which among the following bodies? The subordinate courts within a district, including the district judge, is under which among the following bodies? Subordinate courts किसके अधीनस्थ होते हैं, किसके अंडर होते हैं? Subordinate courts within a district, including the district judge, is under which among the following bodies? Parliament, Supreme Court, High Court, or Principal Civil Judge. So you will eliminate Principal Civil Judge because it does not make any sense. That is something that we know, that Principal Civil Judge of a district is called as a district judge. So we'll eliminate that because district judge is already mentioned in the question. We just want to know that ये जो district judiciary होती है ये किसके अंडर होती है. तो सबसे टॉप पे होता है हाई कोर्ट, उसके अंदर होता है डिस्ट्रिक्ट जज, डिस्ट्रिक्ट जज के अंदर होते हैं अदर जजेस या अदर कोर्ट्स. तो आपको दिखाई देगा, इसी को हम लोग कहते हैं डिस्ट्रिक्ट जुडिशरी, और जो लोअर जजेस होते हैं उनको हम कहते हैं सबऑर्डिनेट जुडिशरी। समझ में आया? सबऑर्डिनेट जुडिशरी। तो सबऑर्डिनेट जुडिशरी वैसे तो डिस्ट्रिक्ट जज के अंदर होती है, पर आपसे कह रहा है सबऑर्डिनेट कोर्ट्स प्लस डिस्ट्रिक्ट जज किसके अंडर होता है? सो इट इज अंडर द हाई कोर्ट ऑफ इंडिया, एंड दैट इज अगेन इनकरेक्ट। हाई कोर्ट ऑफ स्टेट होना चाहिए, या सिंपली हाई कोर्ट्स लिखा होना चाहिए था। ठीक है, हाई कोर्ट्स ऑफ इंडिया लिखा होता तो सही हो जाता। ओके, क्वेश्चन नंबर 11। सो सी इज द करेक्ट, सी इज द करेक्ट ऑप्शन। बाय एलिमिनेशन विल कम टू सी। डजेंट मैटर हाउ grammatically incorrect the option was framed. Next, question number 12. Okay, so this is the repetition. Okay, question number 12. Now, who can increase the number of judges in the Supreme Court of India? Again, it is talking about the changes in the quorum of Supreme Court of India. The Chief Justice, the Parliament, the Governor of the state, or the President of India. So please understand, President does not interfere. President does not interfere in judicial matters. President does not interfere in judicial matters, and that is what we have fought in our freedom struggle. We have tried to separate the judicial power of the Governor General of India from himself, and we wanted to create a parallel mechanism which will be which will not be biased on policies and white and black and all of this. So President of India has assumed the powers of Governor General, or you can say Viceroy. So President does not really interfere in the functioning of the judiciary, though the President can seek advice of the Chief Justice of India from time to time on various matters when it comes to interpretation of the Constitution. Secondly, the President also has some sort of judicial powers, because these powers are relating to pardon, remission, respite, reprieve, right, or any other such statutory remedy or relief that has to be provided to a convicted person. Now, that does not mean that the President of India has the power to absolve culpability of any individual or offender. The President of India has only limited power where it can reduce the sentence or reduce the punishment. So किसी को अगर मौत की सज़ा सुनाई है तो उसको आजीवन कारावास में राष्ट्रपति बदल सकता है, लेकिन राष्ट्रपति नंबर ऑफ जजेस की संख्या सुप्रीम कोर्ट में कभी नहीं बदल सकता है. गवर्नर ऑफ द स्टेट इज इन विद इन द स्टेट एंड सुप्रीम कोर्ट इज एट द यूनियन लेवल, सो वी एलिमिनेट सी. When it comes to A and B, the Parliament of India or the Chief Justice of India, the right answer would be that it is the Parliament of India who can increase the number of judges by subsequent amendments introduced. Okay, so I think आपका सही हुआ होगा. तो 13th क्वेश्चन की तरफ बढ़ते हैं, एंड दिस इज़ वेयर द स्टैंडर्ड ऑफ द क्वेश्चन विल इज इंक्रीज्ड. थोड़ा सा यहाँ पे आपको अतिरिक्त नॉलेज लगाना पड़ेगा, बट नथिंग इज बियॉन्ड योर सिलेबस. इट इज़ देयर इन द बुक. इट्स ऑल्सो अ वेरी डायरेक्ट एंड ईजी स्टेटमेंट बेस्ड क्वेश्चन. Which among the following statements is incorrect? You have to choose the incorrect statement. There are only 24 high courts in India. This statement is correct. No high court can function for more than one state or UT. Tribunals are selected or created to supplement the functioning of the high courts. This statement is correct. Constitution of India has given adequate powers to the high court. This statement is correct. The only incorrect statement is B, and this is why it becomes the answer. And also, if we apply the logic, there are 28 states, but if there are 24 high courts and we say that this statement is correct, then it means that there are 4 such states whose power are associated with one of the 2 high courts. So there can be high courts. For example, if you take Punjab and Haryana example, and that is what we had already discussed in our lecture 1. So please, if you are watching directly the MCQ part, okay, not a problem, but try to watch the concept lecture first and then try to supplement it with your practice lecture that we are going to do here. All right, and that is the in description box. Also in description you will find the link to the concept lecture 1, and you can watch it and then come back to the same practice lecture. Moving to the next question, that is again a statement based question, and possibly the last question from the series of judiciary lecture 1 की practice sheet खत्म हो रही है हमारे पास. Which among the following statement is correct with respect to मुंसिफ courts? मुंसिफ courts के context में कौन सा statement सही है? So this is the 14th question of the day. I hope you would have already chosen the correct answer. Statement आपको correct बताना है, correct statement. They function below the subordinate courts. They are equivalent to district court. That is incorrect, because if A is correct, then B becomes incorrect. They usually handle civil matters. This is also correct. And then therefore the answer would be both A and C statements are correct with respect to municipal courts. And where we had seen this in our lecture, we were discussing about the pecuniary limits of a court is decided by the state government. And there we had seen that in subordinate courts, there are other courts also, very small municipal courts, who look into the civil matters and decide upon petty monetary matters. These courts are called as municipal courts, and they are below the district judge, which who subsequently is below the high court, right? So this was Harsh Vardhan Tripathi on the lecture series of legal studies, practice lecture 1. This was our first practice lecture. I hope you would have enjoyed already, and I'll see you guys in the next.